হ্যালো ফ্রেন্ডস, এই মুহূর্তের গুরুত্বপূর্ণ আপডেট প্রাইমারি শিক্ষক নিয়োগকে কেন্দ্র করে। এই প্রাইমারি শিক্ষক নিয়োগে যে টেট প্রশ্ন ভুল হয়েছিল 2017 সালের প্রাইমারি টেটে অনেকগুলা প্রশ্ন ভুল কিন্তু হয়েছিল এবং তার ওপর কিন্তু মামলা কলকাতা হাইকোর্টের সিঙ্গেল বেঞ্চে প্রথমে করা হয়েছিল। তারপর সিঙ্গেল বেঞ্চকে চ্যালেঞ্জ করে কিন্তু ডিভিশন বেঞ্চে যাওয়া হয়েছিল এবং ডিভিশন বেঞ্চে এমনকি পর্ষদ চ্যালেঞ্জ করে। তো এই প্রশ্নভুল মামলা 2017 সালের পুরোপুরি যে লাইভ আপডেট, যে লাইভ হিয়ারিং, গতকালের যে লাইভ হিয়ারিং, সেটাও আমি তোমাদের সামনে অন স্ক্রিনে তুলে ধরবো। তার আগে তোমাদেরকে জানিয়ে দেবো সেই টেট প্রশ্নভুল মামলার যে লাস্ট বা টেন্টেটিভ যে হিয়ারিং কবে রয়েছে বা পরবর্তী যে শুনানি কবে রয়েছে, পরবর্তী শুনানি সেটাও আমি তোমাদের সামনে অন স্ক্রিনে কিন্তু এই ভিডিওর মাধ্যমে কিন্তু তুলে ধরবো এবং যে কবে রয়েছে এবং সেই দিনই যে টেন্টেটিভ ডেট যেদিন রয়েছে আর একদিন পরে সেদিন কিন্তু কোনোরূপভাবে আর হিয়ারিং বেশি হবে না, শুধু একটা অর্ডার দেবেন ডিভিশন বেঞ্চের বিচারপতি দ্বয়, মাননীয় বিচারপতি হরিশ টন্ডন এবং মাননীয় বিচারপতি প্রসেনজিৎ বিশ্বাস। তো আজকে আমি তোমাদের সামনে প্রথম সেই টেট প্রশ্নভুল মামলার টেন্টেটিভ ডেট তুলে ধরব এই ভিডিওর মাধ্যমে এবং তারপরে পরে কিন্তু আমি তোমাদেরকে গতকালের মানে 21শে জুন যেটা শুনানি হয়েছিল সেই হিয়ারিংটা কিন্তু আমি তোমাদের সামনে অন স্ক্রিনে তুলে ধরব। তো এই প্রশ্নভুল মামলাকে কেন্দ্র করে কিন্তু ব্যাক টু ব্যাক যে নতুন ডায়েরি নাম্বার ডিভিশন বেঞ্চে হয়েছিল, সেখানে কিন্তু ব্যাক টু ব্যাক হিয়ারিংয়ের ফলে আমরা অনেকেই জানতে পেরেছিলাম যে বেশিরভাগ মোডটা রয়েছে কিন্তু ওয়েস্টবেঙ্গল বোর্ড অফ প্রাইমারি এডুকেশনের দিকে। কিন্তু গতকালের যে হিয়ারিংটা হয়েছে এই হিয়ারিংয়ে কিন্তু জানা যাচ্ছে যে পিটিশনারদের পক্ষ থেকে কিছুটা আশা রয়েছে, মানে পিটিশনারদের দিকে এই কেসের মোড়টা কিন্তু কিছুটা হলেও ঝুঁকে এসছে বা বেঁকে এসছে বলা যেতে পারে। এখানে কিন্তু পিটিশনারদের কিন্তু জয় হতে চলেছে আলটিমেটলি। তো শুধু 2017 যে টেটের প্রশ্ন ভুল তা নয়, তাছাড়া 2022-এরও টেটের প্রশ্ন ভুল রয়েছে, তার উপরও মামলা রয়েছে। বেশিরভাগ মামলাটি কিন্তু 2017 আর 2022-এর যে টেট প্রশ্ন ভুল মামলার ওপর কিন্তু ডিপেন্ড করছে পুরো প্রাইমারি প্যানেলটি। তো এক্ষেত্রে আমরা জানতে পাই বিচারপতি দ্বয়রা এটাও জানিয়েছেন যে এক্ষেত্রে কিন্তু 2017 আর 2022-এ যে টেটের প্রশ্নভুল মামলা ছিল এর রায় বা অর্ডার কিন্তু প্রায় সেম হতে চলেছে বা একই হতে চলেছে। তো আজকে আমরা জেনে নেব প্রথম টেট প্রশ্নভুল মামলার যে টেন্টেটিভ হিয়ারিং ডেট, মানে আপকামিং যে হিয়ারিং ডেট কবে কি আসছে, এবং তারপরে এই ভিডিওটিতে পুরো থাকবে, লাস্ট পর্যন্ত থাকবে কিন্তু তোমাদের যে গতকালের লাইভ হিয়ারিং বা লাইভ শুনানির যে আপডেট সেটাও। তো তোমরা যদি এই চ্যানেলে নতুন হয়ে থাকো তাহলে অবশ্যই আমাদের এই চ্যানেলটিকে সাবস্ক্রাইব করবে, আর যদি ভিডিওটি ভালো লেগে থাকে তাহলে অবশ্যই চ্যানেলটিকে একটু লাইক করবে, যদি ভিডিওটি ইনফরমেটিভ মনে হয়ে থাকে অবশ্যই চ্যানেলটিকে শেয়ার করবে। তো তাহলে আমরা জেনে নেব সেই টেট প্রশ্নভুল মামলার পরবর্তী শুনানি ডেট কবে রয়েছে। আমরা এই মুহূর্তে রয়েছি কলকাতা হাইকোর্টের অ্যাফিলিয়েট সাইডের ই কোর্সের সেকশানে। তোমরা দেখতে পাচ্ছ আমি যে কেসটির কথা বলেছিলাম আগে তার ডায়েরি নাম্বার এখানে সব কিছু ইনক্লুড করা রয়েছে, কেস টাইপ মেড, ফাইলিং নাম্বার দেখতে পাচ্ছ, রেজিস্ট্রেশন নাম্বার দেখতে পাচ্ছ 1008/2024। ফার্স্ট হিয়ারিং ডেট যেটা রয়েছিল 24 মে, কিন্তু নেক্সট হিয়ারিং ডেট যেটা পড়েছে আর একদিন বাদে মানে 24 জুন 24 তারিখ পড়েছে। স্টেজ অফ কেস শুধু সেদিন কী হবে, অর্ডার দেওয়া হবে। পুরোপুরি মামলাটি কিন্তু বিচারপতি দ্বয়রা শুনে নিয়েছেন, পুরোপুরি যে ঘটনাটা বিচারপতি দ্বয়দের শোনা হয়ে গেছে, শুধু অর্ডারের অপেক্ষা। এবারই কার বেঞ্চে আমি অলরেডি আগে থেকে বলে দিয়েছি যে জাস্টিস হরিশ টন্ডন এবং অনারেবল জাস্টিস প্রসেনজিৎ বিশ্বাস। তারপর বেঞ্চ হচ্ছে ডিভিশন বেঞ্চে হচ্ছে, যেটা তোমাদেরকে বলে দিই এখানে যে পিটিশনার রয়েছে এটা হচ্ছে ডব্লিউবি বোর্ড অফ মানে ওয়েস্ট বেঙ্গল বোর্ড অফ প্রাইমারি এডুকেশন অ্যান্ড আদার্স। অ্যাডভোকেট হচ্ছেন কৌশিক চৌধুরী, আর রেসপন্ডেন্ট যে রয়েছে সে হচ্ছে ইয়াসমিনা খাতুন অ্যান্ড আদার্স। আর এখানে যে কোজ লিস্ট নেমটা রয়েছে এখানে ডেলি কোজ লিস্টে কিন্তু ওটাকে পাবলিশ করা হবে এই অর্ডারটি। এবারই গতকাল কিন্তু নতুন একটা ক্যান ফাইল অ্যাডমিশন করা রয়েছে, তার আগে একটা ক্যান ফাইল অ্যাডমিশন করা হয়েছিল যে 10/6/2024 মানে 10ই জুন, কিন্তু গতকাল কিন্তু আরেকটা ক্যান ফাইল করা রয়েছে মানে অ্যাডমিশন করা হয়েছে, যেটা দেখতে পাচ্ছ 21/6/2024। এবারে কোন পার্টি করেছে যে প্রশান্ত পাল অ্যান্ড আদার্স তারাই করেছে। এগুলো সব পেন্ডিং মোশনে রয়েছে, ইন্টারলোকিউটরি ডিটেলসে যদি তোমরা দেখতে পাবে। এবারে লাস্ট যে হিয়ারিং হয়েছে সেটা গতকালই হয়ে গেছে। এখানে কোনো রকমভাবে ওরা ডিটেলস এখনও পর্যন্ত দেওয়া হয়নি হাইকোর্টের দ্বারা। তো আমরা সেই লাইভ শুনানিটি শুনে নেব, যেটা গতকাল কিন্তু 2017 প্রশ্ন ভুল মামলা নিয়ে কিন্তু হিয়ারিং করা হয়েছিল কলকাতা হাইকোর্টের ডিভিশন বেঞ্চের বিচারপতিদ্বয়দের দ্বারা, হরিশ ট্যান্ডন এবং মাননীয় বিচারপতি প্রসেনজিৎ বিশ্বাসের দ্বারা। তাহলে চলো সেই লাইভ ভিডিওটি আমরা দেখে নিই এই মুহূর্তে।
Item number 27. What is the law on this subject? Do the court interfere with these kind of a matters? Comes with the control.
I tell your lordships, with my little knowledge, unless it is palpably shown to be wrong or it is incorrect so palpably, then court should not.
Where the junior or Mr. Bhattacharya
Went live with
the court of the university.
Exactly.
Consult the books.
And then
Give his opinion. Mr. Bhattacharya. Child development. A child psychology is a very specialized subject. No, the opinion was given by the specialized people, not by him. He was permitted to go in the academic and research on it to get him satisfied whether this can be done. And no, he doesn't have. He did not give an opinion.
my point that this takes as the basic point. Then what is in the petition?
The order has not been challenged.
Petition is baseless.
That order
This is
has
simply dispute.
reached its finality, number one. And let him finish.
But I tell you, lordships, in the main petition, the first one, 5 questions were disputed. But if I take your lordship to the petition, in respect of one book or the textbook, a copy was annexed. In respect of the other, nothing. In the petition itself. Now, this is my basic point. If the petition does not disclose any authority as regard to showing that the question is palpably wrong, the court should not.
There are two things. One is that the question is wrong. And it is completely another thing that the answer
Key answer wrong.
is completely wrong.
Key answer wrong.
So there are two terms. Because the framing of the question is absolutely wrong. This could not have been done.
But here your lordship, key answers wrong.
Yes, sir.
And that's what I'm saying, there are key answers wrong. Now, my lord, then your lordship's court exercise jurisdiction. Send him to, my lord, library, collect documents, try to emphasize it. But I'm questioning this process first. Then, is it a robbing inquiry? Dispute it first. By way of a petition, flames the petition, collect the materials, question it before the court. Then what was?
In one sentence, you wanted to say that the jurisdiction cannot be used as a tool for a roving investigation or inquiry.
In regard to key answers. That's.
Investigation or inquiry.
Now this is first. Then your losses kindly consider this matter. I just tell you, this is now the method probably everybody follows, every recruiting authority. Key answers is first published. Objections are invited. Then your lordships, expert committee appointed by the recruiting authority. Then they publish the final key answer. But here one point.
Answer is what? If there is any objection,
They consider it.
if on consideration,
On consideration.
whatever the expert body which is constituted, they found that the objection is sustainable.
Then they correct it.
Correct.
That has been done over here. Now, here one more point. This is the first petition. This is in regard to TET 2017. The petitioner did not file any objection. Now, this is one of the point. Because this sort of matter, your losses we find from our experience. One petition filed, then thousands of come. On the same plea. Your losses will find that even the amendments almost the same. Because once get an interim order, so It's flooded.
Fact is that though she participated or he proved
She.
he participated in the examination, but she did not raise any objection when the answer he was published.
Exactly. Now here your lordships, the final after consideration of objection corrected key answers published and result published on 10th January 2022. Kindly see the writ petition files after 6 months. Now the problem is that the authority has to proceed further. Now no process will come to a logical conclusion if this happens. It goes on and on. Now here your lordships, what happened after that? They came up before this court. I will take to your lordships all the orders. Now, my lord, the court says you appoint your own expert again. We appointed it. We gave the report. Now the court do not consider the report, says third party appoint. Now, my lord, I took a post in your lordships. I appointed since post direction was there because twice the expert opened. The first question set out all are experts. All are either professors of the university or the college or the even at least the renowned headmasters of any institution. Now this was again, my lord, after receiving objections, my lord, scrutinized or reconsidered, final answer. Then it comes before the court. Court asking me do it again. I did it, appointing another committee, not the same persons. This is our affidavit. Now we did it. Court did not do it at all. Consider the prima facie view. Look, this is your answer. First, this was corrected answer, and now this is third expert. The court is not an expert. Court say prima facie satisfied. Well, what is the basis of it? To appointing a third agency. Now, if the third agency says, suppose my answer, one answer is wrong, key answer. Now, would you lordships believe whom? What is the basis of it? But if I tell your lordships, Vishwabharati is appointed here, your lordships. Vishwabharati is not such an expert in the, at least in the science subject, that they should be taken accept. Why do you not believe me then? Why will you not believe me then? What is the inferences of the court? Then it will go on and on. One must to put an end to it. But I am not saying, there are several types of questions. I tell you, lordships, in several matters, your lordships, there are options which are, according to the guideline of NCT, those are, 10% of the questions to be kept for the ascertainment of the quality of the teachers. Now, your lordships, there are certain answers which are nearer to one, each of one. Two answers are nearer to each, but one is correct. Now, I say, my expert said this is correct. But what is the authority every time to question it that this is incorrect? There is no malafide in it. Everybody appeared on the basis of this. So this is happening if I take one after another order, your lordships kindly go through it. The first your lordships will find yesterday I placed it 7th September 2022. That's your lordships here at page 98. If your lordships consider it, kindly
First, to a writ petition which is filed and what was the remedy which was sought.
exact. I just that's at page 36. Exact.
62, 69, 70.
Your lordships kindly come to the next page. There is a question booklet series. YZE.
What is this?
I tell you, lordships, my lord. I tell you, my lord, for sanctity of the examination, questions are for all same. But my booklet may not tally with my learned friend booklet. The same questions. Suppose your lordship 62 question in YZE series. That question might be 81 in CBE series. So that one cannot copy with the others. This was the method followed. Clear to your lordships. There are 5 series if I am not wrong. I mean petition clear. This is the method followed, your lordships. Questions are same, 150 questions are same.
One can understand.
Because so that one cannot copy in the examination hall.
So choice question.
Multiple choices. So this is followed, Malad. 62 might be in another booklet series, will be 81. In another booklet series will be 101. Like this.
Oh my God.
Now, here your losses will find this is the prayer in the read petition. Kindly come to pleadings of the read petition, page 26, paragraph 7A, capital A. Page 26. I just read out. Your petitioner states that the question number 62 of section 3, child development and pedagogy subject, states as follows. Which one of the following skills should be stressed more for mentally underdevelopment children? Key answers were life skills, B, adaptation skills, C, communication skill, D, numerical skills.
It should be the answer.
They say A is the answer. Now, if I take your losses to the authority doesn't speak so clearly.
Can be very frank. This is such a curious question or confusing question that there could be a multiple opinion in this regard.
Certain questions are kept your losses for assessment.
I had a last time.
Yes, I have heard your losses.
Actually was not there because I am now dealing with a juvenile. I am a member of the Juvenile Justice Committee of the Calcutta High Court, dealing with all the children at the homes, which includes this mentally challenged or special child. Now it is called this special child. How to treat them, it all depends upon a particular examination or other examinations. How to do it. One is something from a strong. That's the that same impacts to but suffering from that. Not support that or to on it to be, so that's why it's called it a care plan. ICP, it says every special child they have to become. Life skill is also one of them. There are kits just come up in the market, and these kits are really used only in a learning process. In fact, as a committee, we have donated a lot of those adaptation kits to many of the homes.
My submission is that all these questions has to be considered keeping in mind the fact that this was meant for the recruitment.
Of questions are being put which has a multiple.
No, here your losses would not be. I tell your losses. Here would not be. Because I tell that's your losses. Inferential process Supreme Court says cannot be adopted. I am palpably wrong, it can. If it is
Skill is also one of the.
I tell you, I will take your losses to their authority annexed. I tell your losses, these questions has to be answers, has to be considered keeping in view for which class of students you are going to teach. So this is Malad up to class 4. So adaptation skill is more adapted rather than life skills. If the child grows after 12, Malad age 12, 14, then Malad life skills. Adaptation skills for Malad up to the primary stage, elementary stage.
Multiple. Oh, it.
So that's the point, your losses.
They are called adaptation kits.
My way of playing game.
The learning process.
Learning process.
For a learning process.
Well, the question now, should the court interfere with this? This is the point. I am coming. Appointing a third party agency and interference.
Yes.
Then your losses kindly come to this. The next question, paragraph 8. Question number 69, section 30. 4 MCQ questions, 1, 2, 3 and 4 are correctly answered by 0.5%, 20%, 50%, 85% of the students respectively. Now the key answers, your lordship, A, B, C, D.
Remaining the same.
Other things remaining the same, the best question is, now your losses come to the next page. What I am pointing out to your losses as regards the appointing of third expert. The answers key supplied by the concerned respondent, question number 69 of section 3 child development, was answered as option C, which is incorrect, and the correct answer is option D, option 4, D. Now, my lord, my point, what is the, my lord, the basis of your saying this? Because this question, my lord, Supreme Court said, prima facie this should be treated as correct, because this, I will show the judgment, because this was framed by the expert. But no authority shown. Then you answer question number 70 of section 3, child development and pedagogy subject.
69, they have not said anything.
Anything. Now, your lordship, sufficient number of questions are set on the same concept in a test. Test is achievement type, diagnostic type, prognostic type, criterion reference type. That in answer key supplied by the concerned respondent, question number 70, child development is incorrect, option B. The correct answer is the criterion. No authority shown. What they have tried, your lordship, pause here for a moment. After going to library, they correct certain material and try to say this is the correct answer. Is it the process, my lord? No authority. And this writ petition multiplies thousands of writ petitions. Then your lordship, paragraph 10. Your writ petition states question number 125 of section 5 of environmental science. But kindly see where we get maximum cotton of 1 kg by the help of spring balance. A pole, B 45 latitude, C 45 longitude, D equator. The answer in the question by the, we said, my lord, equator. My lord, I am little knowledge, but I have read it, our answer is correct. Now, your losses, they say according to this, the correct, since option D is the wrong answer, you have mentioned that. Pole, according to this should be pole. This is not correct, even my with little knowledge, I am not a student of science. Now, what is the authority cited? I cannot be the expert. The court is not also. So, why the court should entertain this petition? Then your losses, kindly see 11. The question number 110 of section 4, mathematics subjects as follows. Simplify, Sharol Kurun. Malad, your losses need not go through it. Kindly see the last column. This is divided sign. According to them, they kindly see the next page. I'm not reading it out. Kindly see even the last paragraph of the sub paragraph of paragraph 11. Here I put make certain submissions. Well, kindly see the paragraph. This person sat for the examination. He got the original question booklet. He must know what was the sign. He says he is saying it on the basis of website. But is it permissible? The experts filed a report showing all the 5 set of questions, because 5 booklet series distinctly show this is division sign. So you sat for the examination, you must know it, whether this is addition sign or division sign. Just to stall the process, you are doing it. Somehow question it, because court is so lenient to interfere with it. But my point, appointment of third in the expert is an interference. This is all that the writ petition your losses will find. Now your losses go through one after another order, because along with this, thousands of writ petitions came, because court interfering with it. Now my point is very simple. unless
So,
exactly in the petition.
and what expert has said so?
But
That's why on the last episode, yesterday I asked the question that when are you thinking that what are would be a reference books or such?
no, I can't your losses because this is conducted.
The board examinations every unity of the day.
Well, I tell you losses, this is being held by the government well, as an agency by the board of the state government on the basis of the guidelines of NCT. I showed you a lot.
So this is what I really wanted to say. That
I just showed you a lot.
You have chosen a particular textbook.
No, I tell you losses, standard is up to class 10.
So there is no. You're not getting what I'm saying.
I get your losses and I'm not, no book is referred.
So, class 1 to class 10, whatever, you should say that you should follow that here. What is that?
NCT.
NCT guidelines. NCT guidelines complete all the textbooks in their.
Well, may I read out? No. As such, specifically, no, but I can tell you losses.
So, because if the textbooks are.
I get your losses, man. If the answer is there, you cannot question it. And that's get your losses, man. But
I'm asking.
all that your losses, a copy. Kindly have a look at this. I just put it. Kindly, this is the guidelines. Kindly excuse me. This is one book. This is the guideline of NCT.
No, this is a guideline, but
No. Your losses kindly see also how this is to be done. Some indications are there. What is so much? These are all the guidelines. So, took it. This is we just maintain up to class standard 10. And then your losses, this is the basis of the writ petition. Your losses kindly, I will just place your losses 3-4 order, which ultimately culminated to the impugned order. Your losses will find the first order at page 98. 98.
or other writ petition.
This is this writ petition. The first one, Yasmina Khatun, along with 2 other tagged. I placed it your losses. Kindly see here, the learned advocate general appeared. He took a point.
This question number 3, which was not the.
Exactly. Not in this writ petition. This is the, if I'm not wrong, Yasmina Khatun is the first leading matter.
The other 2 matters, this question number 3 may also.
With the
not know the answer of this.
First paragraph.
I must be knowing this. I do not.
No, I'm not aware. This is very difficult. Now, by the course of time, I forgot. If you know, Bangla মহাদ্বৈ সংস্কৃত দুই ভুলে গেছি লিখতে দিলেই পারবো না সাধু চলতি মিলিয়ে ফেলবো সাধু আর চলতি ভাষা মিলালে মাস্টার মাসের তৎকাতি এক চর মারতে এখন তো সাধু চলতি দুই মিশে যাবে
সাধু চলতিতে গলতি
So this is the first order you lost. Now your losses will find questions are multiplying. And entire thing is being done after 6 months of the publication of the corrected key answers. Final corrected key answers. So everybody was on fencing. If let someone go, if the court interferes with it, I will come and join.
What was it said? Change for the channel. Let's put it.
Now, with your losses permission, internal page 3.
That was there because contentions were raised. I do not know by the streets or by you. I do not know. So,
I was not appearing, Malad. I was not.
so doctor was appearing for whom?
For the board.
Which was that they did not raise the notice.
Exactly.
Everything was discarded.
Discarded. And
Says that they let him come prepared.
exactly. Is it the Malad jurisdiction of the Malad? Only one thing, your losses. Not challenge, but it are culminated to the final order.
No, nothing has been done. Then
No, your losses, no. Your losses one paragraph. Internal page 3 of the order, third paragraph. Obtaining objection and obtaining case expert's view are not within the rule. Well, is it right? It doesn't. No recruiting agency does have any rule. Even that probably this court also in your losses administrative jurisdiction. If your losses examination cell key answers published, invite objections, consider the objections, and ultimately final corrected key answer passed. Well, does it require a rule or this is a rule of fairness? The court questioning it also, as if this is done yourself, therefore this should be thrown away.
in the fairness transferring.
Exactly. No, the court questioning it also.
There is no rule. There is no difficulty.
No, certainly there is no rule. That doesn't mean that the executive cannot. No, I tell you losses. I am placing it why? Because this culminated into the
No, this is no culmination.
I am sure to your losses. I beg your losses.
Things which can be deemed to have culminated, nothing, or affects and influences the decision to be taken.
That might end over to your losses.
Something very, very categorical, clear, saying that sorry, I do not accept this condition. I wanted him to come with a more, having a more preparedness in the matter. That was the
that's culminated to final order because court asking him to come prepared with materials.
Sometimes when you argue, he says that these are the materials. It appears to us that you are not fully prepared.
That's your losses in regard to law and Malad authority, not in regard to the material to be supported in the petition. That's not into the material. Your losses never give us time to come with the evidence, new evidence.
Paragraph is the page 2.
Page 2.
The penultimate paragraph, just paragraph above the last one.
Therefore, I hold.
I asked Mr. Doctor whether this exercise undertaken by the board as to correctness of the answer was matter covered under the rule. Since I do not know, then he says that the technical questions cannot be taken as to the truth, which is a matter of merit, so long the judge is not misdirected himself by not following the technical law that you not statutory. And then say that I exhort this matter to one week. When the petitioner will come prepared, if it is found that those two letters I do not know what is this, Mahabran or not, the
Tahito. No, my point is, here your losses kindly consider this. I came up before I think.
I don't think so. It has got anything. It's so important for this purpose.
No, I will just show the one after another order. Then you'll have seen 19th November, this November at page 104.
All petition challenge. Challenge group. No question. Yes.
No. Would you also come back after 10 minutes or?
Oh, it has come
After 10 minutes.
No.
Now your losses, therefore, my lord, I just tell your losses, this is collecting evidence. You therefore, you didn't come before the court with your knowledge as an examiner that this is the correct answer. Lawyers support, you are finding out the correct answer. And then the court appoints expert. Then your losses kindly see the next order, 108. 108. Report 5. Then your lordships 109. It's not. Then 115 your losses. And 110 I have no place, but your losses can go through it also. All the orders have it. Then 115.
Order.
No, 110 is the impute order. 120, I'm sorry. 120 is the impute order. Yes, 120 is the impute. But this order, at least, my lord, why I'm saying it's culminating all the orders into the final order. Paragraph 3 at page 123. This court had made certain observations yesterday in this. So this, my lord, relates to the, or my lord, touches to the other earlier order of. My basic question, your losses also will find in the increment order. After they raise the common disputed questions list, I can appoint another expert committee, and then their views will go to the third expert. So, by this time, your losses will be getting 4 experts committee report except third expert. So, my point is that court interferes with this matter with the prima facie satisfaction. With all respect, has the court considered it in our report, the last expert report, vis-a-vis their dispute? Prima facie satisfaction must be based on some materials, some dealing with the matters that, look, this question palpably wrong appears to be. So this should be go to the, because we are not expert, neither the court is the expert. This should go. This is the judgment of this. And you losses common disputed questions. One writ petition moved after 6 months of the final result. Appointing authority is not sitting tight. They are proceeding with the appointment. Now this is being done. Now obviously someone might say that this report is not correct, this key answer is not correct. My view is correct. My second point is that how do you determine that he is correct? You appoint expert appointed by the court is correct. What is the basis of that? Because all are professors or teachers with almost the same accreditation. You are appointing Vishwabharati. I have appointed the Presidency College or Jadavpur University or Kollani Vishwavidyalaya. Our expert also comes from Jadavpur University. So what is the basis of that, the court? Just because someone comes and court might have looking into it without recording the findings of the court sending it, all the questions. Not one paragraph you lost it, all the 100 questions. Then reduced it to that. Court expressed to that view. That send all the 150 questions. So this is on the point your losses that the expert views, third expert views is not correct. My basic questions, my lord, unless, my lord, it is palpably shown to be incorrect, this should be deemed to be correct. That's the views of the Supreme Court. The past judgment you have also. By way, second point, by way of inferential process, you cannot show that this is incorrect. Then no process of examination will come to an end. Now, my lord, even if your losses, someone says that there are 2 possible answers, it should be left to the expert of the examining authority which one will be nearer to the answer. It's not for the court or to the third expert. Kindly visualize that every question, every process or every examination can be interfered with if this goes on. But the experts, I tell you, losses, would be, can you losses sitting in the court will differentiate between the 2 experts? When the question, some questions come up. Suppose your losses, one questions come up, your losses view, this should be the correct, another view, this should be the also correct. Now, then, therefore, it is to be determined by my expert. Your lordship has to rest upon me, unless something malafide is done. That yes, he says this is nearer to the answer, so this should be. I'm tried my best to ventilate that. That some credence to be given to the authorities. Unless leaking of question papers, answers, all that. This is not the case. Then no process will come to an end. No, even if you lost it with all respect at the cost of repetition, my report was probably not open. I've given to that, everybody has supplied, then upon. At least court must say this is the answer, then after exercise of the law, yes, this is their dispute.
All the registrar general to take the copy and give it.
Well, that your losses passed on 24th April 2024.
So circulated about it.
Exactly.
Or 34. Okay.
No, with the signature portion, except the signature portion, it is open. I'm saying open means the court must consider, court must apply its mind. I'm not saying court expert, but court must come to a conclusion. Look, this is the authority I find. This is the authority of the expert. So there is something to be decided. You go with this question. But it is open to the petitioner. Common disputed questions. This might be 50, might be 25. This exercise of the court and court. So, kindly see, I will just because this sort of matter once very often go up to the Supreme Court also, but I will cite only 3-4 judgments to see why the court should restrain itself. I'm not on that, but the court should restrain itself. But the basic judgment, 1983 4 SCC, page 309. Not everybody by this time were aware of it. The Kanpur University matter first. 1983 4 SCC. Photocopy? Page 309. I just give you losses the paragraph. আরেকটা দাও কি হলো হয়ে গেল এই তোমাদের হয়ে গেল
Okay. So we talk later.
Now I just give it to losses Malar. Para 6, 7, 9, 10. But I think your losses para 6, 7, your losses can 3-0. No, I'm sorry, just 3-0-9 just. Para 16 to 18, 15 to 18. The findings of the High Court raise a question of great importance to the student conduct. Normally, one would be inclined to the view.
একশো পৃষ্ঠা একশো পৃষ্ঠায় ভাবলো তো
Paragraph?
which paragraph
Now, I paragraph your lordship 15 onwards. Now I tell your lordships, your lordships kindly see. The findings of the High Court raise a question of great importance to the student community. Normally, one would be inclined to the view, especially if one has a paper setter and an examiner, the key answer furnished by the paper setter and accepted by the university as correct should not be allowed to be challenged. This is normal. One way of achieving it is not to publish the key answer at all. If the university had not published the key answer along with the result of the test, no controversy would have arisen in this case. But that is not a correct way of looking at these matters which involve the future of hundreds of students who are aspirants for admission to professional courses. If the key answer were kept secret in this case, the remedy would have been worse than the disease because so many students would have had to suffer the injustice in silence. The publication of the key answer has unraveled an unhappy state of affairs to which the university and the state government must find a solution. Their sense of fairness in publishing the key answer has given them an opportunity to have a closer look at the system of examinations which they conduct, which has failed. What has failed is not the computer but human system. Then, Malasik Akhtar, who appears on behalf of the university, contended that no challenge should be allowed to be made to the correctness of the key answer unless on the face of it is wrong. We agree that the key answer should be assumed to be correct unless it is proved to be wrong, and that it should not be held to be wrong by an inferential process of reasoning or by a process of rationalization. It must be clearly demonstrated to be wrong. That is to say, it must be such as no reasonable body of men well versed in the particular subject to regard as correct. The contention of the university is falsified in this case by a large number of acknowledged textbooks which are commonly read by the students and youth. Those textbooks have leave no room for doubt that the answer given by the students is correct and the key answer is correct. Well, let's pause there for a minute. Does it satisfy the states the present one before your lordship? In any paragraph of it, then the students who have passed their intermediate
why erase the question? Ask for that. I asked this question whether there is any reference book in kind of a thing which you have. This is what paragraph 17 says.
and to an extent, but your lordship, there is nothing on the petition that these are the books we follow. The students who have passed their intermediate board examination are eligible to appear for the entrance examination for admission to the medical college. Certain books are prescribed for the intermediate board examination, and such knowledge of the subject as the students have is derived from what is contained in those textbooks. Those textbooks support the case of the students fully. If this were a case of doubt, we have unquestionably preferred the key answer. But if the matter is beyond the realm of doubt, it would be unfair to penalize the students for not giving an answer which accords with the key answer, that is to say, with an answer which is demonstrated to them. Well, this is the stage to be followed before appointing a third party expert. If the state wants to avoid, well, these are lapses to compile under its own as they take to which is specified. Well, this is in respect of it's an intermediate examination. This is not an intermediate exam. Which should be prescribed for the students. There cannot be any prescription of the book Malak for TET examination. Which should be prescribed for the students desirous of appearing for the combined pre-medical test. Education has more than its fair share of politics, which is the bane of our university. Numerous problems are bound to arise in the compilation of such textbooks for various applicants will come forward for doing the job, and forces of the counter forces will wage a battle on the question as to who should be commissioned to do the work. If the state can succeed in overcoming those difficulties, the argument will not be open to the students that the answer contained in the state book, which is prescribed for the test, is not the correct answer. Secondly, a system should be devised by the state government for moderating the key answers furnished by the paper settings. Thirdly, well, this test is satisfied by the inviting objections. Thirdly, if English questions have to be translated into Hindi, it is not enough to appoint an expert in Hindi language as a translator. The translator must know the meaning of the scientific terminology and the art of translation. Fourthly, in a system of multiple choice of objective type tests, care must be taken to see that the questions having an ambiguous import are not set in the papers. That kind of system of examination involves merely the tick marking of the correct answer. It leaves no scope for reasoning or argument. The answer is yes or no. That is why the questions have to be clear and unequivocal. Lastly, if the attention of the university is drawn to any defect in a key answer or any ambiguity in a question set in the examination, prompt and timely decision must be taken by the university to declare that the suspect question will be excluded from the paper and no marks assigned to it. There was some argument before us as to the nature of the relief which can be granted to the respondents. It was contained. This is relief portion here also. I'm really going to get to 18. But this is, I concise my submissions to this. It will also go by the petition first. This is affidavit of evidence before the form. No material. This sort of examination, textbook cannot be prescribed because the standard of the thing, it's always followed the syllabus. Some questions have in stricter sense, some questions in normal, and some questions can be availed of by everybody. So this is the pattern of examination. Now, therefore, kindly see what is the finding of the court on the authorities cited, number of authorities state books. So the difficulty is not distinctly that these effort or reference book that would be followed. If you are conducting an examination for imparting an education for children between the age of 6 to 11, then if you the parameter which you have set forth, what is the minimum eligibility criteria which you have set up for those examinations or the examinations? Minimum qualification must be either class 12, 50% class 12 or graduation with 50% with class 12. Minimum. Now, if there are various boards, there are various the I would say the institutes like an ICSE or CBSE, West Bengal board. West Bengal board. There is a UP board because it is open to all another sundry. There may be another state. Can you not indicate that the questions on each subject, the curriculum or the books which is followed by CBSE or by an ICSE, you can expand it? I think that would be difficulty at your losses. What is the difficulty? NCP is correct to that extent. The standard would be casting. Suppose I am from West Bengal board. My learned friend comes to CBSE. I have never seen CBSE. That would be difficult. What? Because I don't know the CBSE. No. Probably you could not get me. You say that any book which is prescribed by a board conducting a class 10 or a class 12 examinations, that would be taken as a parameter. I believe that there is nothing, because what I gather from all these cases are, there are certain books written by an author not accredited by an NCERT. That's their independent view. Those references has to be are taken that this is the correct view. How one will assess? Now, normally I tell you not. Those are authority. Those are normally the authority are playing of all systems are being. Because this is what a judgment of Justice Chandachud is. So that it says that in the board there is a prescribed. They have been taught in that particular fashion. And therefore, if it is in tune with this, then there cannot be any ambiguity in this regard. This is what just I tell you, Lossi, there is a difference between the TET exam and this exam. No. Please, that was in relation to a medical examination, I believe, conducted by a particular state.
where the outsiders were not permitted to participate unless they show they are domiciled here. In our days, please remember, so far as the West Bengal joint entrance examination was concerned for the MBBS courses, anybody who lives outside the state of West Bengal was not permitted to. It was restricted to a student or a person domiciled within the state of West Bengal. So, for that reason, the curriculum of the West Bengal Board of Secondary Education was taken as a parameter for the purpose of answering. Now, when you opened it for is a pan-India, everybody from any corner of the country may apply. Then you'll have to set a standard. There are many references books. There are many multiple examples which immediately instantly come in my mind. I can give. But I had an option to read certain books. So that is my passion about it.
But I tell you, losses
To read those.
CK guideline is to that extent.
I was having a chat with my brother to